Thanks for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about self-defense and privacy in a police station. Cases that should have gone to the Supreme Court of Canada, but didn't. Michael Ledoux was working for a police department, and unfortunately in the course of his business, he was harassed by his colleagues. To stop the harassment, he set up surreptitious recording devices in various rooms throughout the police station, on the basis that he could use the recordings to show that he was being harassed and defend himself against further harassment. Ultimately, however, his decision to record those things amounted to intercepting private communications, a criminal offense. He was charged, not his harassers, and at trial he argued that he had the defense of self-defense, that his actions were justified in trying to prevent the ongoing abuse that he was enduring. The jury agreed with him and acquitted him of the offense, but unfortunately, the Court of Appeal overturned the acquittal and substituted a verdict of guilty. This case raises a very interesting issue because self-defense typically applies to when there is a threat towards you that's a threat to your physical security. I mean, the classic cases of self-defense, The Outsiders, the very famous novel by S.E. Hinton, a good example of the law of self-defense. But what happens when you're defending yourself against something that's more subtle? The way that attacks on people can happen in an emotionally abusive way, the way that harassment can drive a person to depression, to despair. Can you not defend yourself against those attacks by doing something like recording the conversations and recording what's taking place surreptitiously? And what about the fact that there's no reasonable expectation of privacy in a police station? If you're in a police station, you should expect that you are being recorded. Why was this not a consideration that amounted to an acquittal, ultimately, for Mr. Ledoux? The Supreme Court of Canada had a real opportunity here to help victims of harassment, to help victims of workplace bullying, and to say, yes, the law of self-defense can extend that far and can permit people to do things where their motivations are just. And while certainly in a police station there are some things that maybe you don't want a record of because they deal with the investigative strategies used by police or information in relation to ongoing investigations, if the information is used responsibly for the means for which it was created, to stop the harassment, to create a positive workplace, then why should that not be okay? The Supreme Court of Canada really missed the opportunity here to get in on this developing trend that we have in Canada of protecting people who have been victims of abuse. And it was a really poor step for them not to hear this case. And I wish that the Supreme Court of Canada had said, yes, we hear this, we understand this, and we want to protect the safety and security of people in their workplaces, not just physically, but also emotionally. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Thanks for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Like, subscribe, share with your friends, and thanks to Brazen Bull Creative for putting together these videos.